By 11:47 that Tuesday morning, the senior court security officer who had worked the federal building for 19 years had seen many things. He had seen senators bow their heads at sentencing. He had seen mothers walk back out of holding to their children. He had never, in 19 years, seen a man tell Judge Calloway in open court that her bench was small time. And he had never seen a sneer leave a face the way it left Marcus Vance's that morning. Sergeant Doyle was the kind of man the building counted on without quite noticing, gray at the temples, calm as river stone, a Marine in the bones of his posture. He stood at the back rail of courtroom 9 and watched the gallery fill. He kept a slow tally. Front rows behind the plaintiff's table, an elderly woman with a cane, a retired schoolteacher in a navy cardigan, a man in his 70s wearing a tie that had not been new for a long time. There were 140 of them, give or take. They had been told the night before that they should not expect comfort. They should expect the truth, however it came. The schoolteacher's name, Doyle would learn over the following year of follow-on hearings, was Margaret Wexler. She had taught 5th grade reading in the same district for 36 years. She had retired in 2012 with a public school pension and a small inherited sum from her late mother, the whole of which she had handed to Trinity in 2015 because the glossy quarterly letter had used the word conservative. She was 73 years old that Tuesday morning. She had stopped reading novels in the spring, the day she had received the email that read, with the careful neutrality of bad lawyers, that the fund had encountered an unforeseen drawdown event. She had for 2 months slept 4 hours a night. She had not in that time told her grown daughter. She had wanted first to know. Marcus Vance came in last, the way a man comes in last when he wants to be seen entering. He wore a suit that even Doyle, who did not know cloth, could see was a different thing from a suit. He was 41, sharp-featured, expensive in a way that made the air in the room seem thinner. Behind him, in lockstep, walked 8 attorneys from a Manhattan firm whose name was a brand. Vance ran Trinity Equity Partners. He had on paper $2.4 billion under management. He also had on paper the savings of every elderly retiree in the front rows, savings he had told them in glossy quarterly letters were ring-fenced and conservative. The savings had not been ring-fenced. They had been pushed in the spring into a single high-risk play on a faceless aerospace supplier called Helix Aero Components. Helix had folded in late April. Their savings had gone with it. Now Vance was here for the first hearing of a federal securities fraud case. He sat at the defense table with his arms crossed and looked, for a long moment, at the ceiling tiles. He did not look at the gallery. He did not look at Judge Calloway, who came in at 10 precisely, who took the bench without fanfare, who lifted her reading glasses and began. "This is the case of United States v. Vance and Trinity Equity Partners," she said. "We are here on the government's motion for asset preservation and on the defendant's cross-motion for a stay. Counsel, are you ready?" The lead attorney, a man named Bremerton, stood smoothly. "We are, Your Honor. With respect, this motion is wildly overbroad and reflects a fundamental misunderstanding of how funds of Mr. Vance's size operate. Your Honor's chambers, pardon me, Your Honor's court is being asked to step into a matter best handled in the Southern District, where these kinds of disputes are routine. We would suggest—" "Counsel," Judge Calloway said, "sit down, the motion is before me, I will decide it here." Bremerton sat. Vance smiled the way a man smiles in a meeting when an underling is about to learn something. Then he leaned forward and spoke audibly, without being asked. "Your Honor, with respect, let's all be honest about what we're doing. This is a small-time bench. I have 8 lawyers. You have 1 robe. Let's not pretend we don't know how this is going to end. I have a flight at 4. Doyle had heard a courtroom go silent before. He had not heard it go silent like that. He saw Margaret Wexler's hand close on the rail in front of her. He saw the man in the old tie sit up a half-inch straighter. He saw the bailiff at the front of the room, Garcia, a young woman, only 3 years in, touch the radio at her shoulder, then look up at Doyle. Doyle gave her, very slightly, the tiniest shake of the head. "Wait. Let the judge run her room." Judge Calloway did not raise her voice. She did not look up immediately. She finished the paragraph in front of her, set her pen down, and only then turned her eyes on the defense table. "Mr. Vance," she said, "your remark is on the record. You will not address this court again unless I address you first. Counsel, control your client, or I will hold him in summary contempt. Are we understood?" Bremerton turned a color that was not in his suit. "Understood, Your Honor." "Then we will proceed," she said. "Government, your motion." The assistant prosecutor, a woman named Singh, small, prepared, stood and walked the court through the filings, one exhibit at a time. The first exhibit was the glossy quarterly letter Trinity had sent its investors in February. Singh read aloud the words ring-fenced and conservative. The second exhibit was the Internal Investment Committee memo from late March, signed by Marcus Vance, in which Vance had written in his own digital signature, "We are going to put everything into Helix. There is no other play that pays. We will not communicate the concentration externally." Singh read those sentences aloud once, then again, and then a third time evenly, as though she wanted the room to be sure of what it had heard. Doyle watched the front row. Margaret Wexler did not move. She did not weep. She listened. The man in the tie set his hand on his wife's shoulder. Behind them, an older man in a windbreaker took off his glasses, polished them with a corner of his shirt, put them on again, and went on listening. They were a dignified room. They had not come for theater. They had come to know. Across the well of the court, Vance shifted in his chair. He looked for the first time at the gallery. He did not look long. He looked the way a man looks at a son he has been told. In a glossy quarterly letter of his own writing was a street lamp. Singh moved to the third exhibit. It was a chain of text messages, provided under federal subpoena from a phone Mr. Vance had been required to surrender between Mr. Vance and his chief operating officer. In the third message, Mr. Vance had written, "Just keep telling the retirees we're conservative until we exit. They don't read." In the fifth message, he had written, "If Helix folds, I'll be in St. Kitts before they figure it out." Singh read the messages without inflection. She did not need inflection. The messages did the work. In the front row, the man in the old tie made the smallest sound, not a sob, not a word, just the breath of a man who has finally been told the truth he had already in his bones known. His wife beside him slid her hand into his without looking. They did not turn to each other. They did not need to. They had been married, Doyle would learn later, for 53 years. They had put 41 of those years into the savings Trinity had placed in a single basket without telling them. They had been promised, in writing, conservative. 2 rows back, a woman in a hospital lanyard, a nurse who had taken her father out of long-term care that morning to bring him to the hearing, sat very still. Her father was 86. He had retired from a paper mill in 1992. He had handed every certified pension check, for 30 years, to the man whose name was now on the messages Singh was reading aloud. He had not, his daughter would say later in the hallway, slept the night before. He slept now against her shoulder, the way a man sleeps when the worst possible question has finally been answered out loud by someone wearing a robe. The man in the old tie, Doyle would learn from Halloran's case notes that winter, was named Theodore Petrov. He had been a machinist at a tool and die shop in the same county for 48 years. His wife of 53 years, Anna, had worked the office and the books of that same shop until the shop closed in 2009. The Petrovs had owned, free and clear, a small brick house, 2 used cars, and a life insurance policy on Theodore that they had paid into for the same 48 years. Their retirement in full had been the Trinity account. They had walked, when the Helix concentration had eaten it, into Halloran's office on a Saturday and laid the glossy quarterly letter on her desk and asked, very quietly, whether such a thing was allowed to happen in this country. Halloran had taken the case that afternoon. Halloran would, the following spring, see the first of the receivership distributions delivered to the Petrovs' kitchen table. It would not be all of it. It would be the beginning of it. The beginning, Halloran would say later, was the part that had not at all been guaranteed. Judge Calloway lifted her glasses. "Mr. Bremerton, does your client dispute the authenticity of those messages?" Bremerton consulted briefly with 2 of the 8. "We do not, Your Honor, subject to forensic confirmation." "Confirmation has been entered as Exhibit 12, Singh said, by a federal cyber unit, last Thursday. The judge nodded once. Continue, counsel. Vance had stopped tapping the pen he had not noticed himself tapping. He was looking, now, at the table. He was looking at his own name on the paper in front of him as though he had not, until that moment, understood that the paper had teeth. Singh moved on. There was a March voicemail Vance had left for his head of sales, in which he had used the phrase "the suckers" twice. There was an April email in which a junior analyst had written, in a single careful paragraph, that the concentration in Helix violated the firm's own written investment policy, and that the elderly investor disclosures were materially misleading. The analyst had been instructed to rewrite or be reassigned. She had been reassigned the next day. She had, 2 weeks later, kept a copy of the original draft on a personal drive. The original draft had become Exhibit 7. Doyle did not know much about the law of securities. He knew enough about people to recognize, in the quiet courage of a junior analyst keeping a copy of her own warning on her own drive, the same kind of dignity that had walked, slow and certain, into the gallery that morning. The building, he thought, ran on people like that. The bench at the front of the room had been built for them. The hearing turned then, the way hearings turn when the room understands that the question has already been answered. Singh laid out the requested freeze, an order preserving the assets of Trinity Equity Partners, an order halting outbound transfers from the fund, an order preventing the defendant from leaving the federal district. Bremerton stood again. He fought. He used the long words. He invoked complexity, market harm, the chilling effect on legitimate investors. He was, Doyle thought, a good lawyer, doing the job he had been paid to do. He was not winning. Judge Calloway listened. She let him finish. She did not interrupt. When he sat, she lifted her pen and spoke evenly. On the government's motion, the court finds, on the record before it, probable cause for federal securities fraud and obstruction. The court further finds that the defendant has, by his own words, both an intent and the means to flee. Pursuant to the Asset Preservation Authority of this court, the court orders all assets of Trinity Equity Partners frozen pending further hearing. Pursuant to the relevant federal statutes, the court further orders trading in the fund halted with notice to the federal securities regulator and to the relevant exchanges. The defendant's request for a stay is denied. The defendant's bond is revoked. The defendant will be remanded to the custody of the United States Marshals pending arraignment. It took, Doyle would say later, exactly 47 minutes from the moment Marcus Vance had said the words small-time bench to the moment Judge Calloway said the words bond is revoked. Margaret Wexler did not stand. She did not raise a hand. She closed her eyes for a long second, opened them, and looked at her cane. Vance by then had begun to talk. He started softly, then louder. Your Honor, this is not, I have a flight at 4. Your Honor, you cannot, Bremerton, tell her. Bremerton put his hand on Vance's forearm. He did not look at his client. He said quietly, Marcus. Tell her who I am, Vance said. Judge Calloway folded her hands and looked at him. She did not look angry. She looked, Doyle thought, the way his grandmother had looked when she had finished hearing what she needed to hear. Mr. Vance, she said, the record knows who you are. The record knows what you wrote. The record knows where you intended to be in 24 hours. The record will travel with you to every subsequent hearing of this case. Now, you may speak to your counsel. You will not speak to this court. 2 deputy marshals came forward. They did not hurry. They did not raise their voices. One of them, Doyle knew, Petrosian, a man who had grown up in a town not unlike the towns the front row had grown up in, gave Margaret Wexler a small, almost invisible nod as he passed, the kind of nod a man gives when he has just delivered something a long overdue letter had been waiting for. Vance walked out between them. He did not look at the gallery, he looked at the floor. Outside courtroom 9, in the wide corridor with the tall windows, Doyle let himself, for 1 second, lean against the cool marble of the wall. He watched, through the open door, the gallery rise, not in cheer, not in noise, in the way a room rises after a long service has ended. Margaret Wexler used her cane. The man in the old tie helped his wife. A month later, the first receivership distribution arrived at Margaret Wexler's mailbox. It was not by any honest reading the whole of what she had handed over. It was by the same honest reading more than she had let herself believe she would ever see again. She held the envelope on the kitchen counter for a long time before she opened it. When she did open it, she did not call her grown daughter. She called Halloran. She said very simply, "It came." Halloran said, "I know." It came to 137 other addresses, too. There was a silence on the line. Margaret Wexler said, "Thank you." Halloran said, "Thank you, thank the judge, thank Singh, thank the analyst whose copy is now Exhibit 7. I just did the paperwork." Theodore and Anna Petrov drove, the following Saturday, the 11 miles from their small brick house to Halloran's office downtown. They brought with them a casserole dish under a clean cotton towel and a card in Anna's careful blue-ink hand. They sat in Halloran's waiting room for 45 minutes because Halloran did not, on Saturdays, ordinarily come in. When Halloran arrived, she came in every other Saturday to read affidavits in peace. She did not, at first, recognize the dish or the couple. Then she did. She sat with them for 2 hours on her office couch in plain street clothes, drinking the coffee Anna had insisted on making in the office kitchenette. She listened. She did not that morning say very much. The Petrovs did not need her to. They had not come for the law's voice. They had come to thank in person the small earthly hand the law had reached into their lives by. They left, finally, near noon. Theodore shook Halloran's hand at the door for almost half a minute. Then they went home. The trial, when it began the following spring, would last 17 days. Vance would plead, by the second day of jury selection, to the obstruction and the lead securities fraud count. The plea would be conditioned on the full and unencumbered cooperation of every electronic device, every chat thread, every personal account he had used to plan the Helix concentration. He would name in his proffer the chief operating officer, the head of sales, and 3 outside consultants who had helped him design the disclosure language that had hidden the concentration from the elderly retirees. The cooperation would unwind by the end of summer. 2 adjacent fund managers who had been doing the same thing with their own elderly accounts. None of those names would, before the proffer, have been on any prosecutor's whiteboard. All of them would, by autumn, be on a federal indictment. The receivership, in the meantime, would continue its patient work. The first checks would, by Christmas, have reached every name in Halloran's case caption. The Petrovs would, the following spring, receive a second check. They would, that same spring, repaint the small brick house. Anna would plant tomatoes again. Margaret Wexler would, in late April, finish a novel for the first time in 11 months. She would read it through in 3 nights. She would, after the 3rd night, sleep for 9 straight hours. She had not slept 9 straight hours since the spring of the drawdown email. She would, the following morning, write Halloran a second note. The second note would say only, "I am reading again." Halloran would tuck it behind the first one, in the front of the binder, where she could find them both when she needed them. Designed to run, it would take months, it would take a year. It would, in some cases, take more. But it would not vanish, it would not slip onto a private plane at 4 o'clock. It would sit under seal where the court could see it, until the court was satisfied that it was on its way home. Marcus Vance did not that evening board a plane to St. Kitts. He spent the night in federal custody. He would the next morning be arraigned in a courtroom not unlike the one he had called small time. He would, in the months to come, learn how the record traveled. He would learn it in every motion, in every hearing, in every plea negotiation. He would learn it from a court that did not raise its voice and did not need to. The next morning, when Doyle came in at 7, the lobby was already different. Margaret Wexler came back, not for any hearing. She came back to bring Halloran a tin of homemade banana bread and a thank-you note in handwriting Doyle had not seen on paper in a decade, small, careful, the loop of every letter closed. Halloran would, Doyle would later see, keep the note in the front of the case binder. She would keep the tin, too, long after the banana bread was gone. Halloran read the note twice. She tucked it into the inside cover of the binder. She did not say anything to Doyle when she passed him in the hallway, but she touched the rail by the wall and nodded, the way people did in the building when something had been done correctly. Doyle nodded back. The arraignment of Marcus Vance, which began at 9, went exactly the way the law required it to go. There was no spectacle. There was a defendant in a different suit, a defense table now staffed by only 4 of the 8, an entry of plea, and a long, careful colloquy about the conditions of his continued detention. Vance did not, that morning, address the court without being addressed. He had, somewhere in the long hours of the previous evening, begun to learn how the record traveled. In the corridor that evening, after the building had emptied, Doyle made his last walk through the empty rows of courtroom 9. He stopped, as he always did, at the rail behind the plaintiff's table. He set his hand, just for a second, on the wood Margaret Wexler's hand had closed on that morning. The wood was warm. It had held a lot of weight in 19 years without showing it. The bench at the front of the room was clean and empty. The flag stood where it had stood for as long as the building had been a building. The records of the morning were sealed and time-stamped and traveling, even now, to the next set of hands that would carry them forward. Doyle turned off the last light. He walked out. He thought, on the long walk to the parking lot, about Margaret Wexler's hand on the rail and the man in the old tie, and the way Petrosian had nodded, almost invisibly, as he passed. He thought about how a man with 8 lawyers and a private plane had looked at a ceiling because he could not look at a gallery of people he had stolen from. He thought about how the law, when it was given the room to work and the record to work with, did not need to shout. It only needed to be true, and to be on, and to be heard by everyone who needed to hear it. He thought about the junior analyst whose original draft was now Exhibit 7, who had been reassigned and had, somewhere out in the city tonight, just learned that the warning she had written and been told to bury had become, instead, the spine of a federal record. He hoped someone called her. He hoped she slept better than she had been sleeping. He thought about how it is not, in the end, the big people who hold a building like this one upright. It is the quiet ones, the ones who keep their own copies, who tell the truth in writing on a Tuesday afternoon when no one in the room wanted to hear it, who sit in the front row in a navy cardigan with a cane, who put 41 years of paychecks into the trust of a stranger and ask, when the stranger turns out to be a thief, only that the records see them and the law do what the law was written to do. He thought last about Judge Calloway folding her hands, the small-time bench she had called it. He hoped, somewhere that night, in whatever room he was learning the rest of his life in, Marcus Vance was thinking about that phrase too. He hoped he was beginning to understand what he had said. 47 minutes was, all things considered, a generous education. The dignity of the front row had cost a great deal more than that. It had been restored. It would, with the law's patient help, go on being restored. In the parking lot before he got in his truck, Doyle stopped one more time and looked up at the long bank of dark courthouse windows. The 9th floor, he could see, still had a single light on. He thought, for a moment, that it might be Judge Calloway, working late on the next morning's docket. He thought it might be Halloran, reading the affidavits at the table she had moved into the corner of her office because her real desk was too crowded. He thought it might be Singh, drafting the obstruction memo that would carry the case forward into the season. He did not know which light it was. He knew, with the certainty of a man who had walked the building for 19 years, that whoever it was working for the front row. He thought on the drive home about how the building was built and what it was built for, and how easily the people who came through it for a single morning in their long lives could forget, if no one in a robe held the room, that the building had been built for them. Judge Calloway, he thought, had not forgotten. Singh had not forgotten. Halloran had not forgotten. The Marshal Petrosian, with his small nod, had not forgotten. The junior analyst with her copy on the personal drive had not forgotten. Margaret Wexler, with the cane and the navy cardigan and the banana bread, had not forgotten either. The Petrovs had not forgotten. The 86-year-old former paper mill worker, asleep against his daughter's shoulder, had not forgotten. The room had remembered. The record had remembered with it. The senior court security officer drove home. He slept well. In the morning he came back. The building, as it always did, was waiting.